Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
This is St. Louis on the Air on St. Louis Public Radio. I'm Sarah Fensky, in for Elaine Cha.
Matter of public interest whistleblower is total malarkey. It's my word of the day. It's malarkey. If it were really a whistleblower, you'd send it to the journalist.
I mean, I really hope nobody sends me a tape like this, but
you'd send it to the journalist.
Or you'd send it to the police.
Or you'd send it to the police. You wouldn't send it to Sam Page's opponent because the county executive election was a handful of months away.
I'm going to go back to something I have learned from Eric Banks and all the years that we've worked together on this legal roundtable. I think everybody should just settle with this woman. That would solve everything. Eric, did I get that one right?
Yes, ma'am.
A grieving widow has sued the city of St. Louis over its sluggish 911 response times. A federal judge has told the Biden administration that they may not have certain types of contact with social media companies, and that's because of a lawsuit brought by then Missouri Attorney General Eric Schmidt. And a local conservative blogger being sued for defamation by 2 Georgia poll workers has been told his defense is no good. These are all high-profile cases and developments where we could use the perspective of experienced attorneys. And joining us today for our monthly legal roundtable are 3. First up is one of our founding roundtable members. That is Mark Smith. He's a former associate vice chancellor and dean at Washington University, where he taught law courses for 30 years. He's currently teaching social studies at Narings Hall High School. Mark, welcome back.
Thank you, and I need to say go Markers, I think, now that I'm teaching high school.
Go Markers. That's the Narings mascot.
They're Markers, yeah. I'm not sure. I think it's for Mark of Excellence.
Mark of Excellence, okay.
I'm still learning.
This is an exciting development in your
I'm
life
very
and
excited
in
to
this
be
show.
teaching high school, yeah.
We're also joined today by Eric Banks. He's a former city councilor for the city of St. Louis. He's also an attorney and mediator at Banks Law. Eric, welcome back.
Thank you. Thank you very much.
And last but not least, Sarah Swatosh, who specializes in labor and employment law and is in private practice at the law office of Sarah Swatosh. Sarah, great to see you again.
Thanks so much.
Now, in the past month, the long delays in the city's 911 system have again become a focus of concern for many city residents. A young woman died in a storm after a tree hit her car. Bystanders said they called 911 for more than an hour before help finally arrived. And in the meantime, the woman died. So now the city is facing a lawsuit from a different person who needed help from 911. Richard Schlesing was a sergeant in the Missouri National Guard. His widow says he was driving home from work when he accidentally shot himself. He called 911, couldn't get a response. Neither could family members. He bled out and he died. So now his widow and 4 kids are suing. So is this a terrible, unpreventable tragedy, or is this something, Mark Smith, where the city could maybe be held liable?
Well, I think the first thing to say is exactly what you said. This is just a tragedy, and it's a terrible situation. And like many terrible situations, the law comes in after the fact and the law can't get the solution, bringing this person back to life.
Yeah.
It's not possible. In this case, suing the city, my read of it is this is probably going to be a tough case to win. The city, I think, will be able to come under the exception of sovereign immunity as a defense. And for cities, typically, they kind of divide their actions into proprietary and governmental. And I think and governmental tends to be things that are done for the benefit of all.
Okay.
And so I think here, this will fall within that exception and give the city protection. Now, having said that, there have been a couple of cases in Missouri, one that was similar, where they said it was within the governmental agency. I think it would be different. Like, say, the operator answered the phone, said, help is on the way, don't do anything else, don't call anyone else, and that was not true. That might be different, but that was not the case here. Now, and and I know my panelists here may disagree with me, but and this will help your argument. There was a case 5 years ago in the city where under Crusen's administration, they settled for I think $500,000 for somebody when their dispatcher sent the police to the wrong address.
Okay, now the wrong address, this feels like an error of commission rather than an error of omission, which is not answering. Sarah, how does the city have liability here if the only thing they did was just not pick up the phone?
I think the city definitely has liability here. I think this is a case of negligence. And in negligence, you have to prove a duty, you have to prove a breach of that duty, that a person was injured, and that the breach of that duty is related to the injury. In this case, the city has a duty to run the 911 system. Everything I've read about the city is it's simply not funding the 911 department. There's only a third of the dispatchers' positions have been filled. The EMS positions aren't filled. A third to a half of the calls just aren't going answered. So the city has accepted the duty to run this program, and they're not running it. I think there is liability here. I mean, we tell our children in elementary school, if there's a fire in the house, get out. If there's a problem, call 911. Now, if the elected officials came forward and said, we're not gonna fund 911. We're gonna budget differently. We're gonna prioritize differently. We're not gonna fund it. Then maybe they're not on the hook. But no elected official is going to say they're not funding 911.
Yeah, we'd riot over that.
Yeah, and so instead of being honest about not running the department, they say nothing. And so I think there is malfeasance here. I think there is negligence here.
So Eric Banks, you're a former city councilor. In that role, it would have been your job to try to defend this lawsuit on behalf of the city, get this thing kicked out of court, make sure the taxpayers don't have to pay a settlement here. Do you think that Mark is right and the city would have a good case that they have immunity?
I have a great Harvard Law School response. I don't know. I thought I knew when I came in the door, but after hearing the spirited discussions among my fellow panel members, I don't know what to think right now.
And are you needling our Harvard alumni here, Mark Smith? I believe I detect a little note of that, Mark.
No, I don't think so.
Well, everybody can't get in Mizzou.
I mean, this seems like a tough case. And again, as we're saying, this is tragic. But if I'm on a jury, I'm saying, is this really the city's fault that this man died? Or am I looking at, okay, he's got a firearm in his car. I don't want somebody sitting there playing with a gun while they're driving or whatever might have led to this. Isn't there something where they could say, but for the fact that somebody negligently handled this gun, this wouldn't have happened?
Yeah, that's very good on negligence, because that's one of the causation is one of the elements. I think I agree with Sarah. I think there's a good argument for negligence. I just think when you prove negligence, you get these defenses. And I think here this defense of sovereign immunity would protect it. But you have identified a very good maybe weakness in the negligence, which is a possible causation, although I'm not sure it would work here.
I disagree. I think your but-for analysis is in the wrong place. So pretend assume a surgeon leaves a sponge in a patient then the doctor says, well, if you hadn't needed surgery, I wouldn't have left the sponge. So the but-for doesn't work for me. I think what the causation mark is getting to is, well, the gentleman who shot himself, they're going to need experts. Did he shoot himself in the head and there was going to be no resuscitation? Did he shoot himself in the leg and it was just profuse bleeding? I think we're going to be looking at how gruesome is the injury. And, I think that's probably where it's headed.
And he tried to call, so it wasn't an immediate. So I think, I'm pretty comfortable that they could prove negligence. I just, like I said, go to this defense.
You think there's an immunity? Well, maybe you're listening, have a question. Actually, we know you're listening. Maybe you have a question as you're listening for our panel. You can give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet, or is that an X? I don't know what that site is now called. We're at STL On Air. Send your questions there. Sarah?
I hope there's not immunity. Right, it needs to be fixed. If there's immunity, where's the push to fix it?
And I guess that's part of what I struggle with sometimes in these cases where you want to see the system fixed, but I know that I myself as a taxpayer am going to end up footing the bill for this as opposed to the people who actually have power to fix the system. Do punitive judgments work when we're dealing with a government entity?
Well, and with this case we talked about from 5 years ago, they settled for, I think it was $500,000,
Yeah.
and yet we still have problems with the system, right?
So I want to talk about another case that involves punitive damages here. This is a former St. Louis Public Schools counselor. He got a big jury award this past month. Ron Spivey was a counselor at Soldan High School. A St. Louis jury awarded him $6.1 million over claims of age and gender discrimination. That's $5.2 million in punitive damages. Sarah, you're a labor and employment attorney. What do you think made this particular case such a winner?
Sarah, this is a perfect segue talking about do punitive damages actually fix the problem. So what happened in this case is the plaintiff complained of discrimination. He complained of retaliation. The school didn't fix it. He goes to trial, and the plaintiff asked for a bifurcated trial, which means in the first phase of the trial, the jury determines, are you guilty? Did you do it? And if they come back yes, then in the second part of trial, the jury can assess punitive damages. So in this trial, the plaintiff won, and then the plaintiff was allowed to put on evidence to show that punitive damages are appropriate. And the plaintiff's attorney called the corporate representative, the HR person, and put the HR person on the stand and said, so, have you received any reports of the trial? No. Do you have any plans to do anything different? No. Are you going to change any policies? No. What are you going to do different to prevent this discrimination that the jury found happened? What are you going to do different? And she says, we don't have any plans to do anything different. And this is and then the witness comes off the stand, and in closing remarks, the school's attorney gets up and he uses the word deficiencies. We understand there's some deficiencies, and we're gonna look at these deficiencies, and we're gonna fix the deficiencies, and we're gonna, we're taking this matter serious, i.e., don't punish us too badly, we're going to fix it. Plaintiff's attorney gets up and goes, no, they're not. You just heard the corporate representative, you just heard HR say to you, they're going to do nothing to fix it. Jury comes back with $5.2 million in punitive damages, right? And so the issue is, do punitive damages fix it? We hope so, right? Certainly this jury sent the message that you're not going to do anything, then fine. Pay $5.2 million because you're not fixing it.
But how much of that $5.2 million will the plaintiff actually see with this caps and everything else involved?
There are no caps. This is pre-SB 43.
Oh, I see. Okay.
So the law changed in 2018. After 2018, there are caps on damages. Law prior to 2018, there are no caps. So in theory, this plaintiff, depending appeal, I'm sure it will be appealed, depending on appeal and all those potential settlement. If the school comes forward and says dismiss appeal and pay a lesser amount, but right now it looks like plaintiff's getting 6.1.
And that's because this discrimination happened prior to the law changing versus the day that it goes to trial.
Correct. So it's when the action accrued. So the law changed in 2018. The plaintiff was fired and discriminated against prior to 2018.
A trial verdict is just one step further towards settlement.
Yeah, and you know what? I want to continue to talk just a tiny bit about this Soldan High School case, but there is another employment law case that led to a $6 million verdict that makes that so clear. There wasn't even actually time for a settlement on this. Sarah, can you tell us a little bit about this case in St. Louis County that racked up an equally big verdict, but just it went up poof in a cloud of smoke? That verdict's gone.
Yeah, poof is the right word. So in March of 2023, there was a trial. The plaintiff, his name was Caldwell. It was a disability discrimination, work comp retaliation case. Essentially, he gets injured at work. He gets fired. He says, as soon as I asked for an accommodation, they put me on leave and they never brought me back. He puts it in front of the jury, and I was actually at the courthouse that week, and so I got to see some of the trial. The doctor goes on. Plaintiff does an excellent job of putting on evidence. Jury comes back with a $6.5 million verdict. The defendant filed a motion to vacate the award with several legal basis, and the judge granted it. Wow. The judge vacated, the judge dismissed a $6.5 million verdict. He essentially said that the plaintiff couldn't perform the essential functions of the job. From my perspective, essential function of the jobs is a jury question. If I were the plaintiff, I would be arguing that the judge substituted his opinion for the jury's opinion on whether this plaintiff could perform the job duties. But I'm certain that's going to go up on appeal as well. Yeah. I'm sure the plaintiff will appeal.
I mean, this seems so dramatic that a jury would sit and listen to all this evidence and they come to one conclusion and the judge is saying, hey, actually, I've come to a different conclusion. A judge can just do that.
Yeah, it doesn't happen too often.
Right, exactly. I agree. But the judge, and you might say, well, why does it happen? Well, if the judge lets it go to the jury and the jury comes down the way the judge thinks they need to, it's much less. If the jury would not have found for the plaintiff, it's much harder to appeal and everything. But judgment notwithstanding the verdict or vacating the judgment, it happens where judges say, as a matter of law, I don't think it's the case here.
Yeah.
It's not common. I mean, I think but it does happen. Yeah.
Eric, you're always a vehement advocate that people should settle. You don't always trust these jury verdicts. Have you ever had this happen where they've snatched away a legal victory?
I have not, because most of my good cases settle.
I can see how he comes down on the side. Sarah?
Yeah, the motion of vacate being granted, it's a drastic remedy. We don't see it very often. One of the reasons is after plaintiff stops putting on evidence, the defendant will usually seek to have the case dismissed then, and then the judge denies it. And then the defendant will put on evidence and then rest, and then defendant will again say, please dismiss the case. And so the judge denied the dismissal the first time. He denied it the second time, and he only granted it after the jury came back with a verdict. And the judge dismissed it based on legal reasons. Right. And so I say, well, you knew what those legal reasons were. You didn't have to hear that. Did you hear the evidence? Because if it's just a legal analysis, it could have been granted earlier. So it was a perplexing, a bit of a confusing order.
One of the things I found interesting, and Sarah, it sounds like you've followed the schools case more closely, but my reading was that the jury found for the defendants on the hostile work environment, on gender and on age, but then found for gender discrimination and for retaliation.
Yes, in the teacher case.
In the teacher case.
The school counselor.
I would think the hostile work environment might be easier to prove, because it sounded like, at least in the newspaper, that was a lot of. He spoke about being yelled at in meetings and chastised and treated differently and everything.
So in a typical discrimination case, you have some significant adverse action. I was terminated, right. I was demoted, something significant like that, and that's easy to prove. Mm-hmm. I no longer work here. Mm-hmm. Harassment cases are a culmination of aggressive, threatening behavior. And so sometimes a jury may say, well, did he really yell at you, or was it just an elevated voice? Mm. Or did they really give you a dirty look, or were they about to sneeze? And so some of those nuances of what a hostile work environment looked like can be different to 12 different people. A termination case, that's much easier. You terminated me.
He was terminated illegally because of his gender, or rather than his age, I think, right? It was just on gender, not on age.
I think it was gender, age, but they also gave him a piece for
retaliation. I don't think it was age, though. I can double check my stuff. But anyway, he won, and I agree that it's probably going to be appealed.
It's going to be appealed, but so far the judge has not snatched away $6 million. So that's one victory for the little guy here. We are talking today to our legal roundtable. That is Mark Smith. We're also talking to Sarah Swatosh and Eric Banks. We do need to take a quick break, but when we come back, we'll talk about some St. Louis cases and litigants making some national headlines. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
Welcome back. I'm Sarah Fensky. I'm back for our monthly legal roundtable. Now, this week saw some big news in the defamation case that two Georgia poll workers filed against St. Louis's own Gateway Pundit. James Hoft, conservative blog, had published all sorts of scurrilous suggestions that two poll workers, this is Ruby Freeman and her daughter, had worked to steal the election from Donald Trump. Now, suffice it to say, none of these allegations were true. These women suffered a lot of harassment because of it. They filed suit. And this St. Louis-based blogger, the Gateway Pundit, he filed a counterclaim accusing them, and really their lawyers, of defamation, saying they had actually defamed him. Mark Smith, the judge, ruled on this in the past week. He dismissed that counterclaim.
Right.
Why was that?
So he said these statements, and they apparently pled 7 statements that were made. And we should note that these poll workers are represented locally by Dowd and Bennett, which is a real powerhouse firm. And it looks like it's doing a great job on this. There's also some other groups involved. So a group at Yale and some other groups. And they cited, Gateway Pundit's lawyers cited 7 statements and said, well, these are defamatory. And Judge Stelzer said, no, this is just part of the pleading. You don't get to sue on that.
And by part of the pleading, meaning this is what they're alleging in court.
This is what you're alleging, yeah. They alleged this in the pleadings, and they were just kind of repeating it. There was a interesting piece where they quoted Michael Kahn, who's a local First Amendment lawyer, and he likened this to trying to prove a malicious prosecution case now for Gateway Pundit. So I think the big takeaway is, and the other ruling that came down was Judge Seltzer had assigned a master to look over discovery requests. In federal court, oftentimes the federal judge will assign discovery disputes to a magistrate because I want documents, Sarah doesn't want to give me documents, and we just bicker, and judges hate that kind of stuff. And so, and it's the opposite. Then Sarah wants documents from me, and I don't want to give them to her. And so the most of these cases or their questions were decided in the favor of the plaintiffs, the poll workers. The only thing that kind of went against them was they said they're not going to award attorney's fees as a matter of course. Okay. But I think this is a big win. It's similar in some ways to the national news with the Giuliani case. And I mean, I think you're going to see more of these kinds of lawsuits against people who are going after individuals, not government officials. They have a different kind of standard when you want to prove defamation. But here, these are just regular folks doing their job, and now they're going to get to show their damages and make their case. And I think it's probably a good thing to have people be a little more careful about what they say.
Yeah, I mean, I'm all for the media having certain defenses, but Eric Banks, in this case, it appears that these women were just doing their jobs and they ended up becoming the target of all sorts of nasty harassment that was coming in from all over the country. Do you think that's going to be something where this is going to help if this gets before a jury, that becomes that evidence, just the repercussions it had for their lives?
Absolutely. And regarding the defamation and slander claims in the lawsuit, I don't see it. There's litigation privilege in documents that are filed. So if I file a lawsuit, the law gives me the right to make certain assumptions against the other side, and you cannot then turn around and sue me for defamation, libel, slander, anything that I say in pleadings.
You can say the same things to a journalist or, say that publicly that you would say in your legal filings. There's extra protections in that.
Yes.
Okay. Well, that's we journalists love that. That's how we get lawyers to talk to us. I believe that's how I first met Eric Banks, was calling him for comment about a lawsuit that he'd filed. But as we look at this one, Mark, there's another part of this. This James Hoft, the conservative blogger, he had also filed an anti-slap motion saying, in essence, that these women couldn't have brought this lawsuit against him because this triggered this slap thing. Right. I got to admit, slap is this part of the law I just don't understand.
So they are lawsuits that are brought to keep people, it's kind of like a malicious prosecution. I'm just going to hit you with lawsuit after lawsuit and cost you all kinds of money to defend these suits. And I know they're kind of, and so in Missouri, both Missouri and Georgia have anti-SLAPP statutes. And in Missouri, they are restricted to conduct or speech undertaken or made in connection with a public hearing or public meeting. So if I do that, then I can raise, if somebody sues me because of what I said, I can use the protection of this anti-SLAPP lawsuit. Georgia's apparently a little bit broader, but Judge Selzer said, no, this is a procedural issue, and so we're going to follow Missouri law on this, and so
And SLAPP doesn't apply.
doesn't apply here in this case. Yeah.
So once again, I find myself somewhat bedeviled by SLAPP, but it doesn't apply, so I can just let that go.
One other interesting thing about this case, and I didn't get to see the pleadings, but the Gateway Pundit has been monetizing his
Journalism.
journalism, yes, through the old Locker Dome group. And I'm not sure if they're part of this lawsuit, but there was, reading through, there was some suggestion that they were going to allow discovery about the connection and how he's making money.
So the monetization of this site could come into play.
Could come into play in terms of damages against Hoft, but also might open this other group up to liability.
That's
down the
interesting.
line.
They are not currently named in that, but maybe that's something that's going to change. Let's talk about another St. Louis case, or at least Missouri case, involving the First Amendment. Earlier this month, Judge Terry Dowdy of the Western District of Louisiana granted a temporary injunction. It bars numerous federal agencies, including the Department of Health and Human Services and the Federal Bureau of Investigation, from contacting social media companies, quote, for the purpose of urging, encouraging, pressuring, or inducing in any manner the removal, deletion, suppression, or reduction of content containing protected free speech. This comes from a lawsuit filed by then Attorney General Eric Schmitt. We've talked a lot about some of Eric Schmitt's lawsuits on this show as being things that were designed to raise his political profile. It worked. He's in the Senate. In the past, some of our panelists have been skeptical about whether or not this is going to have the intended effect. Eric, are you surprised to see that a federal judge comes in on this lawsuit and says, I'm actually going to tie the federal government's hands. I'm saying you can't do this as this case goes forward?
I am, and I am particularly careful how I address a subject involving a federal judge, but I personally have issues with a judge in one jurisdiction issuing a command that will affect all 50 states.
And is there something, is there a recourse for the Biden administration in this?
Yes, appeal.
To the U.S. Supreme Court?
No, the Court of Appeals first, then the Supreme Court.
Fifth Circuit has put it on hold. They did that pretty quickly. So, but I think this could. So they're gonna have more of a hearing on with the facts of what's going on. But I agree with Eric. I think this question is eventually going to make its way to the Supreme Court, because on the one side you have the White House saying this has always happened. We use the power of the bully pulpit to kind of get people to do the right thing, and then you have other people saying no, you're silencing certain voices, and it's political. It's not, and so I think this is, like Eric says, going to go to the Supreme Court, and they're going to have to kind of try and draw a line, but I think it's going to be a tough line to draw.
And in the meantime, that injunction is on hold, meaning the Biden administration can continue to contact people in these tech companies. It's interesting. That hasn't stopped our current Attorney General in the state of Missouri, Andrew Bailey. His fundraising email today says, quote, I am proud of our federal lawsuit, Missouri versus Biden, which we are using to build a wall of separation between big tech and the federal government. Biden can't go whining to Mark Zuckerberg anymore, demanding he censor news articles or kick certain people off Facebook due to their political speech. So Andrew Bailey, trying to get elected to the job that he was appointed to, he's now using this case.
And I suspect as a journalist, haven't you had people, I mean, I know I did this when I was in the police board. Somebody would write something about it, some journalist, and I would call them up and say, what are you talking? That's not what happened, and I'm not trying to silence them. I'm just saying you got it wrong, or I don't think this is, or even if they got it right, I don't think this is fair. Here's why. I'm just blowing off steam. Doesn't mean I'm going to, and I think think there should be some of that allowed.
Yeah, on the other hand, I also understand if the federal government called me and said, I consider this misinformation, I want you to bury this or take this down, that is certainly much more chilling to me as an editor.
Right. And then the federal government is different from some little local.
I hear from cranks all day long, and I can't say they bother me too much, but
I actually got in and read some of the order, and the judge depicts the scenario. He calls it a dystopian scenario where the federal government is acting as the ministry of truth. Right. And then he goes through and he actually identifies what the Biden administration wants to remove. They wanted to remove a parody account of Hunter Biden's daughter.
I don't want them taking down parodies. I don't care if the president's son is involved. That does bother me.
That bothers me, yes. And there was a vaccine humor. The Biden administration argued, well, it would dissuade vaccinations. Well, that's too far. And it's not simply hey, will you take it down? We have concerns about this. There were threats of adverse consequences taking away their immunity under Section 230 of the Communication Decency Act. So it's not simply hey, we think there's some misinformation here we're concerned about. We want to flag it for you as a good citizen. It was take it down or you're going to lose your immunity, right? You better behave or there's going to be more consequences. And so I think I would like to think this judge balanced as best as he could. He saw the communications that were being flagged by the Biden government and said, no, it is too far, that you weren't simply advising them of misinformation. You overreached.
Eric, this sounds like something where this appellate court that's going to be looking at this injunction, that there might be two sides here they're going to have to weigh.
Yes, I'll go with that.
So while we're talking about the national news, just for a few quick minutes here, I want to mention a case that has drawn a lot of attention in local circles. Erin Hawley is married to Missouri Senator Josh Hawley. She was one of the lead lawyers on a case out of Colorado. She helped a web designer doing business as 303 Creative, got this person the right to deny her services to LGBTQ couples getting married. And now we know that the U.S. Supreme Court decision in this case, argued by Erin Hawley, this was based in part on false information. The 303 Creative owner, Lori Stewart, said she'd received an inquiry from a same-sex couple to build a wedding website. Lori Smith said it came from a man named Stewart. She included his phone number and email address in court documents. Journalists found this guy, Stewart, after the ruling. He says he didn't make any such request. He's actually not gay. He didn't want her services. He himself designs websites, so he would never need her to design a website. This is some false information this case rests on. I've seen a lot of people saying Erin Hawley should be in trouble for bringing this case based on false information. Sarah Swatosh, your take on this?
Yeah, no, I think we should not be sanctioning Erin Hawley for this. I regularly file lawsuits, and plaintiffs come to me, they explain to what happened, and I have to sort of sort through what sounds like malarkey and what's credible, right? And so I would presume that Erin Hawley saw a name, a telephone number, an email address, and I presume that she proceeded in good faith. And not everything that a plaintiff puts in a lawsuit, it's not that it's false, that it's simply inaccurate, right? So I don't, unless there's some sort of smoking gun evidence that the client said to her, yeah, I know this is malarkey, do it anyway, or at some point she learned it was malarkey and kept pushing it forward, she should be sanctioned. But simply getting a statement wrong is not sanctionable conduct.
Eric,
I don't know if it's sanctionable under these circumstances, but a lawyer has a responsibility to make a reasonable inquiry before he files a lawsuit. I had somebody call, wanting me to file a lawsuit on Monday. I picked up the phone. I called this prospective defendant and said, hey, I'm getting this accusation. They want me to bring a lawsuit. What's your side of the story? And he told me his side of the story, and I was like, I don't want to bring this lawsuit. So I think that we have to we have to go into the details before we file pleading.
Mark, does that include things like fact-checking? I mean, as a journalist, if I'm going to publish this guy Stewart, I'm going to call him up and see if that phone number really is Stewart. Right. Should a lawyer do that too?
Yeah, I mean, you've got some duty, but I agree with what Sarah was saying is that you can rely on your client to a certain extent, if your client's lying, they can be charged with perjury. If I, as a lawyer, I could be brought up for ethical violations if I know they're lying. But I think there's what I've read is there's some suggestion that this may have just been a troll, that they were coming in this way. And standing was never an issue in the case, from what I understand, that it was that both Colorado and the plaintiff kind of said there was a question, and that part of her claim was the 303 creative person was, I want to put this on my website, and before I put it up there, I want to make sure you, Colorado, are not going to come after me. But so I think...
No sanctions.
Yeah, no sanctions, right.
We're talking today to our legal roundtable. That's attorney Mark Smith. We're also joined by Eric Banks and Sarah Swatosh. We're going to take a quick break, but when we come back, we're going to talk about a sex tape in St. Louis County and the Greitens Law. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.
Welcome back. I'm Sarah Fensky. I'm in hosting the monthly legal roundtable. So let's talk about Greitens Law. This was the last bill that then Governor Eric Greitens signed into law before leaving office. And ironically, it was also inspired by the allegations against him that led to him leaving. The law makes it a felony to threaten to release compromising images of a person in an attempt to coerce them. It also makes it a felony to spread private sexual photos without permission with the intent to harass, threaten, or coerce. Violators can do up to 7 years in prison. Now, a man named Robert Ledger of Chicago, or Ledger of Chicago, I don't know, has been charged for his role in a sex scandal involving the then chief of staff for County Executive Sam Page. Robert Ledger allegedly disseminated a sex tape that had been shot by Sam Page's chief of staff. That chief of staff, Calvin Harris, apparently filmed a woman who was giving him oral sex. The woman did not consent or realize that tape was being made, and Harris filmed her in a county government building. His actions on the clock are a matter of taxpayer interest, and Robert Ledger sent this tape to people in government. Now he's being charged with a felony offense. Sarah, could Robert Ledger argue that he's a whistleblower? That lets him off the hook.
No way. Absolutely
not. Not a good defense right there.
Absolutely not. So here's a little more backstory. Mr. Harris videotapes the oral sex. It is in his phone. Mr. Harris has a relationship with a woman named Vaughn. They have a child together. Mr. Ledger and Miss Vaughn also have a romantic relationship. So we don't know how Ledger got the video. Did Vaughn hack into Harris's phone and take the video? Did a third-party operative hack into the phone, take the video? Did Harris brag to his buddies and send the video? We don't know. I don't know what happened. All we know is Ledger gets the video and sends it to Shamad Dogan. Dogan is the Republican candidate, or likely to be the Republican candidate running against Sam Page. And Ledger goes through he creates a fake email address, creates a fake phone number, and sends it to Dogan saying, this is how Sam Page runs his government. So, matter of public interest whistleblower is total malarkey. It's my word of the day. It's malarkey. If it were really a whistleblower, you'd send it to the journalist.
I mean, I really hope nobody sends me a tape like this, but
you'd send it to the journalist.
Or you'd send it to the police.
Or you'd send it to the police. You wouldn't send it to Sam Page's opponent because the county election, county council or county executive election was a handful of months, 6 months away. Mm-hmm. I mean, the theory is Ledger and Vaughn are pissed at Harris, and they're just trying to damage him. They're trying to hurt his career.
And it worked. He got fired over this.
Or there's somebody more sophisticated involved who maybe that's who Ledger got the video from, is sending it to to Dogan so that Dogan takes down Page. There's a lot of unknowns here, but whistleblower, I feel good, is not one of them.
So in addition to having this felony criminal case against this one man, there is also a civil case that also relies upon this pretty new Greitens law that was filed against a number of these players that Sarah just mentioned, including former Representative Shamed Dogan, the woman who kind of had the on-again, off-again relationship with several people, a whole lot of people seeing a civil lawsuit in this case. Eric, does this strike you as this woman who's suing over this sex tape? She has a pretty good claim under Greitens law.
Yes, I do. Yes.
And how so?
Well, I think that the facts are so egregious that you don't have to have much liability to support it because of how just terrible the facts are.
Now, in this case, she sued not only these people who were disseminating this, but also the man, this Calvin Harris, who allegedly shot this video of this happening. He obviously, or we assume, he didn't want this to get out. It led to him losing his job. Does she have a decent case against him?
Well, I think, first of all, I should say this case was brought by Attorney Grant Boyd, who also brought the 911. I just found that interesting.
He's been very busy lately, Grant Boyd.
Right. I agree with Eric. I think this is a really good case. The cause of action says that, it creates a criminal, but it also creates this private cause of action, and it says you can get damages of a minimum of $10,000 or whatever you can prove, plus you get attorney's fees, and that's our system doesn't typically give it. I mean, if it was as Sarah said that he's got it on his phone and he's not showing it to anyone and it's done without his knowledge, well, maybe it's harder to prove then. But they also have, I think, a claim for intentional infliction of emotional distress. I think they're going to win against at least one of these four, if not all of these.
And maybe
four.
that's all that counts is just getting one. Sarah, you might have a different take on this.
The plaintiff's case gives me a little heartburn under the Greitens. So the first element that she has to prove is intentionally disseminates with intent to harass, threaten, or coerce that person.
Oh.
Right? The intent here is to coerce, threaten, harass Harris. She's collateral damage. She is collateral damage. I think that's going to be very difficult to prove that. And the other sort of element she has to prove is that a reasonable person would know that the image is to remain private. If Ledger got this because Harris forwarded it to his buddy and it got forwarded to Ledger, there's no case.
Wow.
I think
if it was not.
If it was hacked and Ledger knew it.
I agree with that.
Yeah, so I think plaintiff's case, while it's got, I always joke, I either get good facts or I get good law. This is a case that has good facts. The law makes me a little bit nervous on this one. I think it could be a challenging plaintiff's case, other than the fact that she's incredibly sympathetic. If you watch the video is out there, if you watch the video, in my personal opinion, she doesn't know. Her body language doesn't suggest she knows. She's not winking at the camera.
Sarah, have you seen this video?
I wanted to prepare. I wanted to prepare for the program today.
I appreciate the homework that you've done.
Look, and part of her claim is she didn't know she was being videoed. So
and you believe that is true.
I do believe. I don't believe she knew.
So this woman has an enormously sympathetic case here, and Eric, I think that's kind of what you were responding to. Is boy, we feel terrible for this woman that everybody's watching this. Even panelists on the legal roundtable have now seen this tape. It's so widely disseminated.
Well, two of them have not.
Yes, for the record, our male panelists did not seek out this tape. I can't believe we're talking about this, and it's entirely my fault. I will say, though, is this something where a jury might be so sympathetic to this woman, and coming back to what happened in a previous case, a judge is going to look at this and he's going to see what Sarah sees and says, yeah, this is contrary to the law. I'm not going to let this verdict stand for you, young woman.
Anything's possible.
Yeah, when you look at these, it says, this is what lawyers, we love to do, is we go over every word and we bore other people to death. But it says intentionally disseminates with this non-consensual, with the intent to harass, threaten, or coerce an image of another person. So, one might argue, well, there was an attempt to harass. The statute doesn't say you have to harass her.
Well, it's the revenge porn statute.
It is.
Right.
But,
So it's
but
not
you still
it's
got
not
the language here. And
Sure.
And like you said, she's a very sympathetic. So I'm not saying that this is correct. I'm just saying, lawyers love to parse language and twist it to their and this is, it's just you feel for this poor woman who's having this video circulated around.
I'm going to go back to something I have learned from Eric Banks and all the years that we've worked together on this legal roundtable. I think everybody should just settle with this woman. That would solve everything. Eric, did I get that one right?
Yes, ma'am.
Well, I think the last piece is this civil lawsuit is pending. There's been one criminal felony charge against Mr. Legger. I understand that the investigation is ongoing. Who knows if anybody else gets charged? So meanwhile, the civil case is pending. I'm sure Jane Doe will want depositions, and I am sure everyone's going to plead the fifth. So I think if they all plead the fifth, like I would anticipate, I would think her case gets substantially better. I mean, it's already good facts, but if they're not going to put any defense forward, it's going to get better.
That's an excellent point. So in our final 5 minutes or so here today, the Missouri Supreme Court is about to see some big changes. Governor Mike Parson will get to choose 2 new justices in a single calendar year. That's something that hasn't happened in 3 decades. And he's already had 1 appointment to the court even before this. Now, if this was the U.S. Supreme Court, this would be a huge deal that he was getting to do 2 in 1 year. Is this a big deal in Missouri? What do you think, Eric? Could this have a big impact on how jurisprudence operates in this state?
Yes, and quite frankly, I think that Judge Parson has made some phenomenally good appointments through the years, and I'm sure he's going to follow through and make 2 equally good appointments for the Supreme Court position.
And that might not necessarily be what some of our listeners would think of Governor Parson when it comes to choosing Supreme Court justices. We might think that he's looking for ideologues, people like that. That hasn't been what you've seen from him so far.
Not at all. Across the board.
Yeah, I would agree with that. I think my politics are probably a little different from Governor Parson, but I agree. I think he's done a good job. And the Gabe Gore appointment, I mean,
that's right. He chose the St. Louis Circuit Attorney who's currently running that office. Yeah.
And you and I talked about this beforehand. In some other states, there has been a politicization of their courts. And Missouri, I think in part because of our Missouri plan. So the way judges get appointed is, the governor appoints them, but he can't just pick whoever he wants. We have a panel that's made up of 3 lawyers who lawyers select, lay people, 3 lay people, the chief judge and they interview, people apply. They send on a panel of 3 candidates, and the governor picks one of those. And I think it tends to make the courts in Missouri less political, maybe a little more just kind of boring, and which is a good thing for the law, where you get more. Everyone agrees with the decision, and I think that's a good thing. And I think it contributes to the legitimacy of the courts, which is important. You don't want courts in a state, depending on who's the judge is, going back and forth with what's allowed or not.
And I have seen that in some states that I've lived in. I come from Ohio, and they have multi-million-dollar campaigns for people running for the Ohio Supreme Court, and they're taking huge donations from people. These are the same people that will end up ruling against them. It seems like the Missouri system, as an outsider to this court system, that you can have more trust on it, at least on its face.
I agree. I absolutely agree. I like the Missouri plan, but it's not without its faults, right? That we have 3 lawyers that are elected by the lawyers, and we have 3 lay people who are appointed by the governor. The commission there's a panel of 25 candidates for a judicial position. The commission, these 6 people, and then the Chief Justice of our Supreme Court come in, and they narrow the panel down for the governor to appoint. This commission isn't as diverse as I would like, right? So the 3 lawyers who are appointed, I believe, are Caucasian this year. The 3 individuals who the governor appointed, he appointed 2 women, which I appreciate, but I don't think that the commission has as much diversity, and I think sometimes that minority vote or that minority perspective could be drowned out a little bit. But I would much prefer this process over elected judges, or I absolutely much prefer it. But I think it could be tweaked a little, the process.
I agree. And I also agree with my former law partner, Senator Thomas Eagleton, who said that the Missouri plan has switched the balance of power from a series governed by outsiders to decisions governed by insiders. So it's just like Sarah said. Yeah, it's not a real diverse group of people who are making the decisions, but I think it should be fine-tuned. I do think that we should keep the Missouri plan.
We could see some tweaks maybe to the Missouri plan. Boy, I'd be worried about some of the bigger changes you might see people in Missouri making. I want to thank our legal roundtable for joining us today. What an interesting conversation. Eric Banks, attorney and mediator at Banks Law, thank you for joining us. And Sarah Swatosh from the Law Office of Sarah Swatosh, thank you.
Thank you.
And Mark Smith, former Associate Vice Chancellor and Dean at Washington University, thank you.
Thank you.
This episode was produced by Danny Wissentowski.
With audio engineering and podcast design by Aaron Dorr.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
St. Louis on the Air proudly supports local artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.